Welcome to the second instalment of the Anson's podcast. Today I'm joined by Martin de Ridder, our Managing Director and one of our directors in the dispute resolution team. And we're going to be talking through a variety of issues around changes in the law and ways of resolving disputes. So we're going to be talking about changes that are going to come into the residential letting arena. We're going to be talking about construction disputes, and we're going to be talking about methods of resolving disputes generally. Unlike last time, we're going to have a bit of a role reversal, so I'm going to be doing some more of the asking of the questions, and Martin's going to be doing more of the talking. And just before we start, as a legal disclaimer, I'm just going to say that this is not legal advice and it's not intended to be. It's intended to be informative. It's intended to provoke discussions. But if you do require advice on anything that you hear, please do get in touch and we'd be more than happy to provide that in due course. The topics that we're going to touch on that we've sort of looked at for this are going to be the Renters' Right Bill, the change in legislation and the changes that are coming in respect of individuals that rent properties. We're going to look at some bits around construction disputes, and we're going to look at a bit about disputes generally.
ADR. Whatever that means, and we're going to tell you.
In due course.
Yes.
So, starting with the renters' rights things, this has been a topic that was brought in it's probably 2 or 3 years ago now, when it was first mooted by the Tory government, and they started making some noise about giving greater protection for individuals.
Yeah, I mean, it actually went further than that. I mean, they did publish a bill. I think it might have even gone through the first few stages of Parliament, which was, or the headline was that it was going to end no-fault evictions. Now, there is a bit of contention as to whether or not there is, that is a good description of what they were trying to do. In essence, there is a whole regime that's been in place since the mid-90s when you rent a residential home. Most tenancies will be called what's known as an assured short-hold tenancy. And what that looks like is it's an initial at least 6-month tenancy. And following that, it becomes a rolling tenancy, which can be terminated on notice, typically at least 2 months' notice. And a regime was created, and you'll have heard this, called a Section 21 notice. And under a Section 21 notice, a landlord, after the initial expiry of that 6-month period, could serve a notice, and there would be no defence to or no ability to oppose that process, provided they got their ducks in a row and they served the correct notice and the correct notice period. The tenant would have a date upon which they would be forced to give possession of the property.
And that's been chipped away at for the last 10 years, hasn't it, with various things being put in?
Yeah, but I see what they did. So on one level, that's quite a big landlord power shift over the tenant on one level. But what the government cleverly did is, look, we're going to give you this sort of nuclear weapon of a Section 21 notice, but in order to have the right to use a Section 21 notice, and there's a court process once the notice is expired to get your possession order via the court, and it's meant to be a fast-track process which is dealt with not by judges, but by the members of the court's admin staff. But what the successive governments, and I think this was a positive step, said, well, you can only get this fast-track possession if, one, the first thing was that if you've taken a deposit, that you've paid that deposit into a recognised deposit scheme. Two, and then it was that you've got the electrical and gas certificates in place. Mm-hmm. More recently, that you've had the environmental heat and surveys, the energy surveys carried out. And if you hadn't got those things, which you have to submit with the court documents, you couldn't get your fast-track possession. Mm. And I think that on one level, from policy perspective, that really did encourage landlords to make sure that all of that stuff was in place, because else they would have a much harder time in regaining possession of their property.
And to a degree, that means then that it was forcing landlords to make the housing better for the renting market.
Yeah, I mean, if you've ever had to get an electrical certificate done and pretty rigorous tests, certainly the same goes with the gas. I mean, it definitely was making sure that properties were more safe and energy efficient, and also, it's a perennial dispute. Lots of, I think we've all had it in our student days. Getting your deposit back at the end of a tenancy was something that was tricky, and the regime that's been introduced there is much improved. There's the deposit schemes that have been implemented. So. Whilst it was this no fault, in other words, the tenant needn't have done anything wrong but could still lose possession of their rented property, it was used as a way of driving forward sort of positive policies within the housing sector and the rented sector. Whether or not that, I'm sure the laws and the obligations will still be in place to do all of those things, if not tightened up further. But whether that incentive will be presumably removed if there is an end to the to the no fault evictions or repossessions.
So that's where we were, and as we've mentioned, the Tory government previously raised certain issues, and the Labour government look like they're going to follow this through with the Renters' Rights Bill. What do you see the changes being in this new regime?
Well, I think that what it will look a lot like is a version of what we have already got, which is the tenant in those circumstances will be could still have the property, could still lose their property that they're renting. However, the landlord will have to have cause. Strictly at the moment, that is still in place anyway, and it's called Section 8 of the Housing Act. And Section 8, it will be a bolstered version of Section 8, which will allow the landlord to recover the property if there are significant rent arrears, if he wants the property back for his own use or the use of his family, or he's redeveloping the property, if there's significant antisocial behaviour. But he will have to prove, in effect, that one of those grounds exists. The downside, of course, is that sounds like proving those things sounds like litigation, sounds like court processes.
I think that's right. That's where we're going to lead to. I think we'll see an extension of Section 8. I think we have to.
Yeah.
And where there's been a lot of criticism, I think is right to say, is where landlords have tried to sell properties and they've been saying, under the current rules, if we want to sell our property, we can. It's better to sell with vacant possession, and therefore we can go through this no-fault process. Do you think that in order to do that, if the no-fault process goes, Section 8 will then have that bolster that says an extra ground or more than one grounds will have to be added in there to give it that?
Yeah, but it is going to be difficult and more difficult, and it already is difficult to obtain possession of the property if you are a landlord, and it's uncertain. Even under Section 21, the no-fault process. If I'm a landlord and it is the 1st of January, right, and I've decided, I've woken up, new year, new me, want to sell my property, and I would send a Section 21 notice. If I served it personally that day, I guess, serve it personally that day, the 2-month period has to expire at the end of a rental period. So presumably people pay at the end of each month or the very beginning of each month. So you would serve that notice that day, and it would be served take effect from the 28th of February. Mm-hmm. However, that doesn't get your property back. You've got to start the court process. And I would currently, to get that possession order, if you filed that possession order on the first day that you could, which would be the 1st of March, if you got your possession date with a possession date before the 1st of May, I would be surprised. That would be really good. Once you've got that possession date, you've then got to apply to court for a county court bailiff to attend to effect the eviction. Well, again, a landlord will have done very well to have got that eviction date before the summer, before the end of July. If the landlord has done that, they will have done well. And probably I would say it'd be more like September with the current court system. So even as it stands with the certainty of no fault evictions, you're looking at 9 months to get your order. Currently, we tend to say to clients, use Section 21 because there's a little bit more certainty in it. But they still, at the moment, can use Section 8. In other words, a fault or have grounds for repossession. The issue there is, again, of course, you are reliant on getting a court date. You serve your notice, and it might be for rent arrears. You, as it stands, and this might go up, and under the new regime, I suspect it probably will. If you've got a certain amount of rent arrears, you can seek. You can go and seek possession.
They've been talking, haven't they, that at the moment you've got to have 8 weeks or 2 months arrears. They're talking about that goes up to 3 months.
Yeah.
So you can see that's going to be an issue.
But just going back to that guy who wants to sell his property, or that person who wants to sell their property, they can use the Section 8 grounds at the moment and serve the required notice period and then start the court process. You're going to have you have to get a judge to agree that is what you're going to do, and it can be contested. You say you're going to use it because you're going to develop the land if you've got planning permission. If you are going to sell the property, they'll want a certain amount of evidence of that intention, sales particulars perhaps, or confirmation that an estate agent has been instructed. It can take, you will serve your notice, but once that's expired, it can take many, many months, 6 months at least currently, before you get in front of a judge to be able to convince him that you have got grounds for possession and getting that possession order. And again, if you do need the bailiffs to effect a repossession of the property, an eviction, again, that will take 2-3 months. So no one is doing anything quickly here at all.
And with the new changes, given the courts are creaking as we stand, what do you see that new change will have? What impact do you think it will have? How do you think it will play?
Well, I can only, unless there's a lot more funding goes into it, and I guess that can only come from increasing the court fees, the system won't cope with it. It's dealt with, unfortunately, in the same department as prisons. So it comes under the Ministry of Justice. We know that the criminal courts are taking years to get to hearings. Unless they can develop a system that sits outside of that, and there is some talk of this via the tribunal service, that they have got lands tribunals, and maybe that could get involved in this process, or a new tribunal system that can, in effect, give, which would be novel, but could give possession orders, then I think that some of this stuff is just going to be theoretical, and I don't, it could just be a complete mess, if I'm being entirely honest, because as ever, as we see in the criminal system, justice delayed is justice denied, and that from both sides of the ball is difficult, because, if you are a tenant, just because it takes a while for the property to be taken from you, there's a lot of uncertainty and disruption to a family's life, not knowing when they're going to need to find a new property. And let me just be clear, for years, if they go to the local authority to be rehoused, the local authority has got a positive obligation to rehouse families. If they go to that local authority, the local authority will typically say, right, well, we will not rehouse you until you are homeless, until you literally have got not the possession date, but an eviction date. So only when you're staring down the barrel of a forced eviction will the local authority step in and provide alternative accommodation. So I don't think it helps anyone, and I do think the law of unintended consequences is likely to kick in here. And actually, the regime where what we really needed was better resourced courts, perhaps a new tribunal created to give effect to the existing laws, so that at least people can have a certain amount of certainty, even if what you do is increase the period accordingly to give tenants better protection.
That seems fair. That seems reasonable. And it's fair to say, isn't it, that at the moment, under Section 8, you issue your proceedings, you end up with a first hearing. That rarely gets matters dealt with. And the problem is that under Section 8, you've got both mandatory grounds, which if you can get into it, you might get possession on your first order, on your first hearing. But if you don't have a mandatory ground, you're on discretionary grounds. Then that means you're going down to trial, doesn't it?
Yeah, I mean, judges rightly, want to be convinced that a family does need to be, or a tenant does need to be evicted from their property or have the property which they are living repossessed. And they will take some convincing. So, under the existing regime, getting a property back into the landlord's ownership is difficult. And
just to put that into context for anybody who might be watching or listening that's not a lawyer, what does that mean in terms of time?
To get you from starting proceedings based on Section 8 grounds, you mean?
Yeah, and to get through to, because effectively you've got to have a trial.
Oh, well, if you've got to have a trial, I mean, from starting the proceedings to a final hearing, well, I would say if you get that within a year, it's a miracle, and I would say 18 months or something like that is currently the norm.
And that's before you've got the bailiffs in, isn't it?
Oh, there's 2 or 3 months that follow after that. So, I mean, and again, to look at it from both sides of the coin, if you are a family fighting that and facing your house being repossessed, that's a long period of time to not have the certainty of knowing that you need to go and find somewhere else to live, right?
Yeah, absolutely. And particularly those who are on the sort of lower incomes, where they are going to be reliant upon a local authority or a housing association to step in.
I don't think the courts particularly are fit for purpose as a way of solving the long-term issue of there not being enough houses being built, not enough affordable rentals being available. Ultimately, the court can have a role in enforcing certain things and resolving certain disputes, but for the policy to, in effect, for the policy to be, you're not going to court possession proceedings our way out of the housing problem, unfortunately.
No, I think that's right. There's also a few other bits within the proposed reforms, aren't there? So silly things like before landlords could refuse people to have pets. Now that's going to be removed so that people are allowed to have pets.
Well, it's yes, there's an assumption that the landlord's got to have reasonable grounds for, being able to deny, good grounds to be able to sort of deny that right or that request.
Yeah, and in some ways, do you think it's a bit of a double-edged sword? Because although landlords can have issues, what the new legislation looks like it's going to say is, well, people can have pets, but if they have pets, they must either have insurance to cover any damage, or the landlord can get insurance and the tenant must pay for it. So really, that's just taking with one hand and giving with the other, isn't it?
Yeah, quite. I mean, you can see there's going to be a load of more disputes around that, isn't there? And again, as I was saying, I don't think our civil courts can currently cope with that. There are some positive developments around the AWAB's law, which is taken from the social housing sector with positive obligations and hopefully some enforcement around.
And just to take a step back, can you just explain the AWAB's law?
So that was in relation to quite a tragic situation where there was a young boy, a young infant, who was living in social accommodation, social landlord, and there was damp and mould, and it was found that was unfortunately what caused his death from respiratory issues. And in that case, the family had complained to the landlord or the housing association on multiple occasions to remedy the situation, and ultimately, unfortunately, tragically, the young lad died, and a regime has been imposed on the social landlords that if in particular in relation to it's all health and safety aspects, but if there is something like mould and a complaint is formally raised, that there's a positive duty within quite strict time limits for the landlord to come out and fix that situation. That should be the case as well, I think, in the private sector. Landlords, if they are making the money on renting out a private accommodation, it needs to be habitable. They need to be sorting out things like mould and carbon monoxide and all of those things, because people do deserve to live in a house that's not going to cause them injury or death. And I think that's got to be the sort of the first obligation. And for that to actually work, there needs to be some teeth to that.
And that's got to be right on two levels. One, people should be living in a certain acceptable level. And secondly, if they're paying for it, then the landlord should be complying with their obligations to keep those properties at that level, shouldn't they?
There's got, a place has got to be habitable. It's got to be fit for the purpose of somebody living in there. It's got to be fit for human habitation, and any bad landlord that's not providing a property that doesn't solve those issues, well, they need to be identified and to be out of the sector, really. There is some talk also of them putting in place an ombudsman, and the ombudsman, and the idea behind that being that actually, again, it goes back to the same point, really. If you have got an issue of your boiler hasn't been repaired, or there's some issue in relation to the state of repair of the property, taking a claim through the courts isn't going to get you anywhere, and to have it's not going to get you anywhere fast. Whereas an ombudsman who could, in effect, order a landlord takes certain steps, perhaps with the right to impose fines or damages, it could be a good way of ensuring compliance with some of the rules and regulations around repair and deposits and all the rest of it.
And seeing an ombudsman in that nature wouldn't really be new to this sector, would it? Because we've already got that as part of the deposit scheme.
Yeah, so the deposit scheme is, they have to be registered with the government, but they are private systems. Most landlords now use them. They certainly need to use them if they want to get a Section 21 notice, as we saw earlier. And I would say that, broadly speaking, I'm sure there will be some horror stories out there, but broadly speaking, that's been a positive development over the last 10 years or so. And I think the expansion of that out to achieve some other policy goals, such as the landlord's obligations around repair, I can see that as a positive development, really.
Just as an aside, and just to throw it out there, would you say that these policies are anti-landlord? Would you say this is a move politically to remove individuals?
We're non-political on this podcast. I suspect that there probably is some of that behind it. Again, ultimately, we're lawyers, not politicians, and not people able to solve. I think you can't get lawyers to solve some of these problems. I ultimately think what needs to happen is more houses need to be built with higher standards, and if better housing is built, that is ultimately what will solve the problem. I think that for the most part, most of the landlords I deal with are good landlords, do want their tenants to be safe and to keep paying their rent, and only look to retake possession of property when they need the property back for their own reasons, or if the tenant isn't paying the rent or is engaged in some kind of antisocial behaviour. I think that is, for the most part, there aren't that many bad landlords out there. Clearly, those that are need to be rooted out. Whether they're going to achieve it, and that is what I am saying here, and I'm sceptical that this is what that this is going to have the aims of the policy versus what happens in reality. I think, unfortunately, are going to be two separate things. So you see how I dodged answering that question there?
Don't know what you mean.
We act for both landlords and tenants, so we are not anti-landlord or anti-tenant or pro either of those things. And I was going to say I've been a landlord and a tenant. I haven't really been a landlord. I have been a tenant. I have been a tenant a few times over the years. Have you been a tenant?
Yeah, a few times.
Did you get your deposit back?
Probably not.
Yeah, my student deposit was never ever. It was, the house was horrendous. That was never going to be returned, unfortunately. But
yeah, probably right. That dovetails us nicely, actually, into sort of the next section of what we were going to talk about. And we were going to talk about construction, and you were just talking about construction of new housing and the projects that need to work around there. Now, you've a number of years done quite a bit in the construction industry around construction disputes. And now we're looking sort of the relationship between the contractors, be it the site owner and the person building it, or a contractor and a subcontractor. And it's right to say in those circumstances, there's a slightly different dispute resolution mechanism, isn't there, for them? And you've done quite a bit of this. So do you want to...
Yeah, so it's really what this topic came out of something that I've noticed recently. So from, again, around the same time, from the mid-90s, there was a Construction Act which imposed a dispute resolution regime around payments on the construction sector. And the reason for that was often the people higher up the chain were practicing rough justice by not paying their contractors and subcontractors, and sites were being ground to a halt over these disputes. And they imposed the regime, including a compulsory payment process with deadlines, relatively short deadlines, and a method of resolving that dispute called adjudication, where if a party was unsatisfied with an application for payment that they had made, or indeed that had not been responded to within the required period of time, that they could get an adjudicator imposed, a kind of sort of private judge, albeit they weren't always lawyers, and a lot of the time they're sort of chartered surveyors, that they could start an adjudication process, and that would lead in a relatively short period of time, typically a month or thereabouts, to a decision, often with an award of a sum of money that needs to be paid from that contractor to that subcontractor, or an order that, or a decision that a sum of money wasn't due to be paid. And
just to step that back for those who may be watching, listening, tuning in, that aren't lawyers, don't have any knowledge of the process, can you just explain an adjudication? So
an adjudication is and we'll come on to this later, is a form of alternative dispute resolution, whereby a contract, or indeed the law generally, imposes a system whereby a party is appointed, called an adjudicator, who sets out certain rules of the game, and then for filing evidence and for filing a claim, for filing the defence stroke response to that claim, and the evidence that he wants to see, he will then consider that pretty quickly and then make a decision which is preliminary binding upon the parties. Ultimately, if they wanted to enforce it, they may have to go to court to enforce it, but at least you've got the decision. The courts virtually always impose or adopt the decisions that the adjudicators make. It's less formal than a court process, but the real benefit of it from everyone's perspective is its rapid justice.
And part of the rapidity of it is to do with the fact that you don't have to call witnesses, you don't go, do you? It's all done on paper.
Typically all done on paper. They've got powers to have hearings if they want to, but for the most part, the party who's got the dispute will file a notice of reference. There will then be a defence stroke response document which contains the evidence within that, and then typically the party who started it will get a chance to reply to that, filing all of their evidence, all done on paper, and then very quickly you get to the end decision, which again is typically, whilst it can't be enforced by adjudicator, they haven't got those powers. If you ever do have to take it to court because the contractor or subcontractor or whomever is the paying party hasn't paid, you will virtually always find that the courts will stand behind that decision and give judgments in favour of the adjudication award.
And often, if you do have to enforce before a court, you can issue proceedings and you issue a summary judgment application with it, don't you? So
exactly that. So you can get your judgment pretty quickly. However, for the most part, what you do tend to find happen is that once an award is made, that the paying party will then make that payment. They don't want the additional costs of having a court judgment either entered against them or to deal with that, because if they're being advised, they're going to be advised that the chances are they're going to be ordered to make the payment that the adjudicator has made.
So in the construction industry, that's a pretty effective resolution method, isn't it?
It is. It is an effective resolution method. I mean, the thing that I have seen that has changed, I mean, you mentioned about housing sector and the housing sector has seen this and have been dealing with these sorts of both the payment application process that is imposed by the Construction Act, but also the dispute resolution process, probably for 20 years. What I have noticed is parties using that process, invoking the Act in relation to other parts of what you could broadly consider to be the construction industry, but not where it was being used before. So I've seen it in relation to hire contracts for electrical installations. You're hiring, in effect, a heater from a hire company, albeit there is some installation that goes in. And I've seen a party taken to... I've seen a party taken, the Construction Act invoked there, and there being an adjudication in relation to those issues. I've seen it in telecoms, where typically you weren't getting many adjudications in relation to installation of fibre optic cables. All of a sudden, parties using the documentation, the pay less notices, payment notices, in a sector of the economy where typically previously parties would just submit an invoice at the end of the month and expect it to be paid at the end of the next month. But all of a sudden, in a far, far wider areas of the economy which are construction related, we're seeing those, the Act being invoked.
And are you seeing that as in the Act being invoked itself, or is this something that parties are now drafting into their contracts between them, or is it a bit of both?
Well, a little bit of both. And unfortunately, and this is why, often why we become involved, is you do get subcontractors, especially people further down the chain in a construction process, and they just sign those contracts. And they have these regimes in place, and it's fine because each month they do just submit their invoice, and most months afterwards, or whatever the payment terms are, they do mainly get paid. That's fine until all of a sudden the project might have started to lose money, and perhaps the paying parties identified a problem or an issue which they can put on the contractor or subcontractor. Then all of a sudden they might get hit with this substantial pay less notice, and this month's this month's invoice is not getting paid. And what do they do, and have they complied with what the contract says about making the relevant applications? Often they will find themselves outboxed, outgunned by a clever QS who's working for the paying party, who knows their way around the Act, and it will leave that contractor sort of outboxed really, and in a difficult position.
In terms of it, in that sense, then is it adverse to the smaller subcontractors, to the chippies, the brickies that are on site doing the job? And do they find themselves effectively where before they had a position where they'd stick their invoice in, then they could just go off to court if it wasn't paid? Are they now stuck with a regime where their contracting party, whatever that may be, can turn around and just say, well, I'm paying you less, tough?
They can, albeit double-edged sword to be invoked here again. Actually, I would say that this process to resolve the disputes in whichever direction, yes, they might get outboxed by the notice game and filing the relevant applications within the relevant period of time. But if they properly engage and understand and read the payment process which they are subject to, actually, in some respects, it provides a much better and quicker way of resolving those disputes which do arise. If you were to issue a county court claim, again, with this, we're like a broken record on this, but if you were to issue a county court claim for a 10 grand invoice that was disputed, you tell me, when are we getting in front of the court to make a decision for that?
Well, you've got another problem in front of that, haven't you? When you've got an ADR, an adjudication clause, or the Construction Act is invoked, actually the courts, the other side can make an application to stay the proceedings, can't they?
Well, no, that's you being a smart arse there, Jason. But what I'm saying is it takes ages if you have to go to court. And I'm saying that you're right. I mean, technically, actually, if there is an adjudication clause, that's what, you're meant to get it resolved, and courts will not, will say you need to not pass go, do not collect £200, go to the adjudicator and get that sorted out there. They will. But what I'm saying is that if those subcontractors can properly engage with the contracts and the purchase orders and the documentation that they are subject to, we're always going to say this, but perhaps consult a lawyer or perhaps consult a QS who is in the know. In the long run, I suspect it's something that is positive for the sector, but you have to. But if you're not aware of it and you just sign whatever piece of paperwork and you only look at the technical aspects of what you've been having to do, the construction aspects, what needs to be plugged in where and all of that sort of stuff, how many bricks need to be ordered or whatever. If you don't pay regard to the payment processes, you can come unstuck. But if you do pay regard to them actually, and there is a dispute, I think it's a much better regime than what you've got in other sectors of the economy. Yeah. In contrast, actually, to what we were talking about earlier, that resolution of housing disputes. I think that the construction regime is much better than what we're left with in the housing sector.
And just as a simple example of that, I think you've probably just got to look at, well, if you issue a claim, you issue it, the other side have then got 14, 28 days to respond, and that's before they've put the defence in. Then you could have months of litigation. Actually, in the time that you've put your claim in and the other side have responded in the court, you could probably have your adjudication result, couldn't you?
You would get I mean, sometimes they get extended by, I think there's power to do it by about 2 weeks. But from I liken it to a late night microwave hot dog. Other brands are available, but not a good. But the Rustler, is it the Rustler hot dog? It is the Rustler hot dog. You get them in garages, and naught to taste in about 60 seconds, and sort of you can start to and finish a construction adjudication in 6 weeks, or certainly even before that, with a fair wind, and that is much preferred than spending 18 months, 2 years involved in an expensive court process. So, yeah, I think that I would say that if you're engaged in anything that is almost quasi-construction, looks a little bit like it's a construction sector, properly getting to and understanding your documents and your order paperwork and contracts is really, really important, but ultimately will be beneficial to you if there is a dispute that you need to resolve.
And just to pick up on a point that you've sort of touched on there, if you're going through the adjudication process, the costs of doing that compared to litigation are going to be significantly less, aren't they?
By a margin, a tenth of the cost, if that. I mean, the downside is you don't get your cost back typically. Whoever loses normally has to pay the adjudicator. Depending on the size of the costs, the adjudicator's costs might be, for the type of dispute that we're involved in, sort of around £10,000, £10,000 to £15,000. You do have to pay your own lawyer's costs, but if you win, if you win, unfortunately, you don't get your cost paid. But if you lose, you aren't on the hook for your opponent's costs, which you are in the regular court system.
So not only is the costs of doing it significantly lower, actually the certainty that goes with it is also a reason that you might be more likely to invoke it, isn't it? For
sure. I mean, I'm pretty positive about adjudications, and just that, I've come across over particularly last 2 or 3 years clients who've got themselves in knots and got themselves into difficulty, really because they haven't properly looked at and understood the payment regime that they are subject to, either because there is a document which sets it out and they haven't properly read it, or indeed if they are engaged in construction work and there isn't a contract, there's a statutory regime and they don't understand that either. So look at your contracts, people. That's what I'm saying.
Fair enough.
Or refer them to us and we can have a little look at them for you. Although, in terms of building anything ourselves, I'm not if you want an extension on your property, I'm not the man to fulfil that at all. I'm extremely... I'm told that I'm very good at digging holes. There's a couple of people when I've had to do a bit down at my local rugby club who are really impressed at my ability to dig a hole with a spade, shoveling.
Not dig yourself into a hole.
I do that too, but honestly, it's a weird thing. I'm quite surprised that they think that I'm a good... Yeah, that's all I'm capable of doing. Anything with any kind of skill, or I couldn't lay a brick, or hang a picture on a wall even. Is it embarrassing that I've had to get like a man in to do that for me?
That's impressive.
Can you do that?
Yes.
Yeah, fair enough. I can't. I got last time I did it, I got something on the internet. It was basically like a sticker hook thing that I put on the wall. And actually, to be fair,
was that level?
It was level. Yeah, I did use a level. What is it?
Spirit level.
Spirit level. Yeah, water level. I was going to call it. So anyway, don't listen to me at all about building anything. But a construction dispute or a building contract, give us a shout and we can definitely help there. And in particular, if you are struggling to get paid, or you believe that you've had an invoice and a payment that you wish to dispute, we can help with that.
Okay, moving swiftly on, and we've already been touching upon this. One of the things that we were going to talk about today is ADR, Alternative Dispute Resolution.
Yes.
And this is really the term that's given to it by the courts, and they call it they were calling it alternative dispute resolution because they wanted us to consider, as lawyers and anybody in a dispute, alternative methods, i.e. don't come to litigation. Let's look at what other methods could be used to find a solution, wasn't it?
Yeah, you've heard us today setting out and explaining why the court system takes a long time, is expensive, and for the longest time since all of these reforms actually go back to the late 90s, but since the introduction of the civil procedure rules in around 1999, there's been a big push from the judiciary, the overriding objective of the civil procedure rules, the white book that we are subject to, which is our sort of Bible, encourages parties to resolve disputes, judicially, but also to act cost effectively. And one of the methods that they one of the methods they've tried to achieve that goal has been to push and encourage parties to engage in ADR. Now, for the most part, that form of alternative dispute resolution, what lawyers hear when somebody says ADR is mediation. And that's the most common form of ADR that is used. But my understanding is, and you know more about this than me, but there's moves to make mediation compulsory. But before we get on to that, you need to probably explain what mediation is. Okay,
so mediation being where you force the parties to come together, or voluntarily come together, I should say, rather than forcing them, and you appoint a mediator who's an independent third party who runs between the parties trying to get a deal. They're not binding, so you don't have to come to an agreement in them. You can have the advantage to them is you can do all sorts of weird and wonderful deals that isn't possible because a court will often say, yes, you're right, no, you're wrong, and will award accordingly, whereas you can have more constructive agreements come from a mediation. So you can have weird and wonderfuls, which
apologies, a court can't order apologies, a court can't order, you go and finish the work on my bungalow.
It can't award, unless there's a trust point, it can't necessarily award that a certain asset be transferred in payment of something.
Or a confidentiality
agreement. Yeah,
I mean, public court proceedings are always public in most circumstances.
Absolutely. So it keeps it out of the public domain, and it can shortcut and it can quicken a resolution to a problem.
In a mediation, there is normally a mediator. And what does a mediator do in a mediation?
Their role's purely to try and get the parties to talk to see if they can reach a settlement. they are not interested particularly in the merits of the case.
Who's going to win or lose?
Who's going to win or lose?
They sort of engage in shuttle diplomacy typically. I mean, you will often find your traditional mediation, you go to a barrister's chambers or to a hotel, you sit in one room, your opponent's with your clients, your opponent sits in the other room with their clients, and the mediator kind of walks between the two rooms, listening to what the other parties have got to say and trying to come up with a deal, really. That's my experience.
That's pretty much it. I mean, sometimes you have round table discussions with everybody in the room, but they don't.
I'm not the keenest on them, if I'm being entirely honest.
A pure commercial discussion and a commercial dispute where there's no personal feelings involved, then they can work quite well. But where you've got anything else where there is one party feeling aggrieved on a personal level, it tends to spiral into a bun fight pretty quickly if you're not careful.
Yeah, and I think, and again, I mean, I went into practice in 2001, so virtually all my career has been in the era of both the civil procedure rules. Often they used to be called the Wolf reforms, but all of my practice has been under that regime and has had mediations involved in it. And they have changed a little bit. I mean, I think like anything, we sort of try to import them whole scale from America in the first instance, and the ones that I went to in the early 2000s, virtually no one would make an offer before 6 o'clock. You'd do your deal at 11 and then you'd be up trying to draft the settlement into the early hours of the morning. Thankfully, they progress a lot more, well, for the most part, progress a lot more quickly and professionally these days. You're not into any of that, having to be typing a settlement agreement at 1 a.m., which was how it used to be. But there are some changes as well. You've dealt with a number of remote mediations.
Yeah, certainly through the COVID period, it was very difficult to get people together, and that inspired more use of things like Teams and Zoom, and they can be very good. Sometimes the problem you have is if parties are either acting in person or if everybody is separate and not with their lawyer, sometimes getting the focus there can be difficult. Whereas what we've adopted occasionally when we have to do these, if we can't do them in person, is to have the lawyers and their clients sat together and then the mediator and then the three parties remote. And the advantage to that is, one, you can help your clients along a lot more. Two, nobody's sat at home, so they're doing their normal day job, and you can really get them to more focus. Yeah. And drill down into those issues. And that seems to work much better. And also, of course, from a purely practical point of view, if you've got a Teams meeting with 15 people on it, you can have problems with connections and all the rest.
And also getting a date, right? I mean, it's easier to... There is one major drawback, though, of remote mediation.
In what sense?
Sandwiches. That was always a highlight of a mediation for me. Again, I'm talking the heady days of the 2000s. I mean, you could go through several trays of sandwiches. When you do it remote and you're stuck in your offices, I'll sometimes send out for a couple of, somebody can do a run down to Greg's, I guess, but it's never quite the platter of sandwiches that you used to get in the 2005 at some hotel in central Birmingham. But more cost effective, which is what we're trying to do, and probably better for my waistline. So I said this earlier, I think, but I always considered I always said to my clients, you virtually have got to mediate, because if you don't, or you can't say to the judge you've engaged in some form of ADR, there is a chance that a court, even if you win your case, could penalise you in terms of costs. But also, I mean, I always thought that getting a case settled is much preferable, even as a lawyer, than taking it to trial. But something's changing, isn't it? Mediation becoming compulsory?
Not yet, but I think it's on the cards. Where we are as of this month, dispute resolution is now able to be ordered by the court. So the court can literally say, you must go and try ADR, and it will be open to what that might look like. They're backing that up again. Now, this isn't new. This is the old regime, and this is coming from about 10 years ago, where the court changed and it started having the powers to order costs, which is what you were referring to earlier.
Yeah.
And if if before you'd unreasonably refused to join and try ADR, the court could award a winning party the other side's full costs against them on the most serious of cases. But the CPR is changing so that will be bolstered as well. And also it's going into the overriding objective that parties have to consider ADR and consider, and some people are also now not calling it ADR, they're just calling it dispute resolution. And they're saying...
You did that when you said your first sentence there, I noticed that. I thought you hadn't called it alternative.
Yeah, this idea of being alternative, we're really moving away from. That seems to be driven into 2021. There was a report by the Civil Justice Commission, and the Master of the Rolls at that point was saying, look, this shouldn't be an alternative. It should be part of a package. And we're now seeing that. And there was a case last year for the first time in Churchill where it started to say, the court said, yes, I can order parties to engage in ADR. And that's a move away, because previously the court always had to say, we don't have the power to order parties engage in ADR. It's got to be something voluntary, it's got to be something contractual. So that's a significant move forward. And that comes back to this 2021 report that was suggesting actually compulsory ADR might be a way forward in the future. And this takes us a step closer to that.
I think there's lots of lawyers getting their knickers in a twist about that. And I think that ultimately... As I say, I've worked on this. I've always advised clients to participate in it and try and participate in an ADR. It's in their client's best interest to do so. To the extent they're making it more compulsory, is that possible? Or they're encouraging it further. I only see that as a good thing. And anything that's getting matters on disputes resolved outside of the trial and the court system with everything that involved is positive.
Yeah, I think that's right. As a stance, I think from an academic point, it's quite an interesting one, because it's, well, what can the court order? Can the court now start ordering an expert determination rather than a mediation? Or does it really mean that it can order mediation? That's just something that's quite interesting. In terms of will it work? Actually, you know what? We do have regimes already where there are alternative dispute mechanisms in play. So, for example, employment tribunals are a brilliant example, because you've got to go through early conciliation before you can get there.
And as I said on the last podcast, I was quite impressed with ACAS recently. What, a form of ACAS for commercial disputes, maybe?
Maybe. It's hard to see how they're going to put it in, because obviously with a commercial dispute, there's a lot of costs there.
Yeah.
Equally, we've seen it to a lesser degree already in the small claims court, because you've got the small claims mediation service. It'll be interesting to see whether it expands something there. And there are, other mechanisms, and there are other places where this mandatory, we were talking about adjudication earlier in construction matters, another good example of where you've got to go through something before you can get your teeth into the litigation. It could be a positive step. I can see there being a lot of fringe litigation on what it is, what it looks like. I can see there being lots of academic argument on it. But let's face it, anything that ultimately moves our clients closer to a swift resolution has got to be a good thing for all concerned.
We're positive about this. And this report, I was interested there, was by the Master of the Rolls. And as I was going to say, like my experience in the early 2000s of mediation, I considered myself to be the Master of the Rolls. I preferred a triangular sandwich, but if it was in a roll form, I would enjoy that. Who is the Master of the Rolls?
At the time, it was Sir Geoffrey Voss.
Okay.
And it was a commission that
Big fan of Greg's, was Geoffrey Voss?
Maybe.
Yeah, I'm sure he would have been. Your favourite Greg's item? Top three. Give me your top three Greg's purchases.
I wouldn't know.
Probably
a sausage roll.
I'm steak bake. I would say number one, albeit they sometimes can be too hot. I then do quite like the chicken bacon baguette. And actually, and this might surprise you, I'm also partial to a vegan sausage roll as well. Does that surprise you?
Stuck for words.
Well, that's not a dispute that we can easily resolve.
It's not. But yeah, so there's a step towards alternative dispute resolution. We didn't touch on it before, but it's probably a good idea to touch on it. DR or ADR, it's not one thing. So we've got mediation. We've talked about adjudication already. probably worth touching on arbitration. Martin, do you want to?
Yeah, I mean, an arbitration is very similar to the adjudication role, and a lot of contracts, particularly international contracts, you will have an arbitration clause, and that is almost like a private, not involving the court system, but a private regime for resolving disputes. It will often look a lot like the courts, will often cost about the same as the courts, or will normally be quicker than the courts.
I think it's fair to say we crossed swords on at least one in our times, haven't we? And
yes, you won. Yeah. So this is before Jason joined us. We had an arbitration together, and he keeps bringing it up. But he did win. And the actual final arbitration was during your notice period before you joined us.
It was.
Yeah, so I was always slightly gutted by that result. But there we go. It proves that we could act extremely professionally, even though we were shortly after that hearing we're about to be colleagues. I mean that is pretty bad form for you to raise a victory over me in this format, really.
I was just talking about it in terms of the swiftness of getting it through was pretty quick. And
less than a year certainly, and a lot of them can be resolved, in less than 6 months. And the actual systems in terms of rules around witness statements and disclosure are reasonably similar. We'll do another. I won't get into disclosure today, but I'll explain another podcast what that means. But a lot of the directions that an arbitrator will set out look a lot like what a court would do, really.
And also having the arbitrator as an expert in their field, who you don't sometimes get this with the court, where the court, you've got a judge who's a lawyer, who could have practiced personal injury law and then could be sitting on a construction dispute.
Yeah.
Whereas in an arbitration, you get to choose your arbitrator, so you can have somebody who is a surveyor or somebody that's got a different background, and that's very positive as well, isn't it?
I think so. I mean, I think judges and anyone trying to resolve any process which involves people who know the area, being involved in it, who's a specialist, can only be positive. Not least because they understand the different names that things are being. They would know what a spirit level was, unlike me, for example. So anyone that has got that level of expertise that they can lend to the dispute is helpful. So I think that brings us to the end of today's discussion.
Thank you very much.